Okay, thanks everybody, and welcome to the October 12th, 2021 edition of NCSL's Office Hours. I think most of you already know that we host these office hours with the intention of giving legislators and legislative staff an informal opportunity to share their stories from their states, or ask questions of their peers, or get a bit of insight into something that may be coming across their desks soon enough. So with that in mind, I do want to say to everybody, this is a great time to ask those questions. If you came with something on your mind, let us know what it is. You can put it in the chat box. You can just ask in the chat box to be able to ask your own question. And you can also email Christy at christy.zamarripa@ncsl.org. She'll put that in the chat box separately. If you want to go to her directly, she will either ask those questions or tell me that I should ask those questions anonymously. I understand that sometimes it's easier to do it that way. So christy.zamarripa@ncsl.org. Anyway, the point is, we hope that we do hear from you. I am particularly excited about today's speaker, and my team can attest that I've been excited for some time that we've got him here. But before I introduce him, I'll let you know that we have two quick other updates coming afterwards. The first is Mandy Zock will be talking a little bit about ballot measures that might be of interest to this group. And then Christy will share with us about one of the cases that the Supreme Court has chosen for this year. And she'll tell us a little bit about what that might mean for campaign finance. And then, of course, again, anything that you want us to address. And, you know, you guys could try to stump us. We do not know everything. So stick something out there hard and we'll do our best, but mostly we'll just come back to you after the fact if we need to figure it out. Okay, so now we'll get on with the show. When I was new to redistricting, which was about 4 or 5 years ago, I went looking for a book that would kind of give me the history of redistricting. And I was very fortunate to find a book written by a real historian, and I have it with me right this minute, On Democracy's Doorstep by Doug Lewis. Excuse me, Doug Lewis is somebody else I know, by Doug Smith. So I got this book, brought it home. I remember the couch and about 10 days every night, read another chapter on the couch. And it's a lot of what I learned in there has kind of stuck with me. And I know that for most people, this wouldn't be considered a page turner, but you all are kind of like me, right? You know, you're in the elections redistricting world and a little on the nerdy side. I think I can say that about most people who work in legislatures. So you also might enjoy it. And you will know after today's presentation whether this is going to be the book for you. In it, we get not only information about that series of Supreme Court cases that you're all familiar with in the 1960s that led to the modern era of redistricting. What we get also is what came before that, which is when districts were wildly different in population. And what we get also is what came after that, which was a fair amount of pushback in Congress to this newfangled system of what we now think of as traditional redistricting. So with that, I will just say that the book is wonderful. I don't really know Doug Smith. We just met 10 minutes ago in the green room, but so far it's been fun to hear what he's got to say. So the floor is yours for about 20 minutes, maybe 30 minutes, and then we'll see where we go with questions. Take it away,
Great.
Doug.
All right. Well, thank you very much for the invitation to speak with you. I'm always happy to speak about redistricting with anyone who will listen, which doesn't happen very often. So it's nice to find a willing audience. Just as a little background on myself to give you an idea of how I ended up writing this book. As Wendy said, I'm a historian. I got my PhD at the University of Virginia, and my training was really in the history of the American South. And my early work sort of focused on segregation and the sort of mid 20th century last vestiges of Jim Crow. And it was actually in this capacity and looking at when in the 1956 in particular, when the Virginia legislature passed a series of school closing laws as a response to the Brown decision. So rather than integrating the school, the Virginia legislature passed a law that said the governor had to close any schools that were ordered desegregated. And there's a strong argument to be made that the vote in the state legislature, which was very close, was determined by the fact that certain portions of the state were overrepresented and other portions of the state were underrepresented in the legislature. And so this was my first real personal exposure to the idea of malapportionment and what did it mean when certain parts of a state were overrepresented and other parts of a state were underrepresented, and how did that play out? And so after I finished my dissertation, my first book, and I was looking for a topic, and I wanted to get out of the American South a little bit, and I kept coming back to this notion of redistricting and malapportionment in particular. And I initially thought I was going to be writing a book that mostly focused on the American South, since that was my training, that was the area that I knew best. And I quickly discovered that malapportionment was a national issue. Virtually every state in the nation by the 1950s and 60s suffered from severe malapportionment. There were a handful of exceptions, which we can talk about later. But it really was something that over the course of the 20th century, over the 50 or 60 years after 1900, had really become more and more ingrained across the nation with pretty serious consequences. I want to take just 1 second to juxtapose malapportionment with gerrymandering. Of course, in all of the work you all are doing now, gerrymandering is a huge topic. It's been front and center for the last several decades. And of course, gerrymandering has been around, for centuries. The term itself dates back to 1807. But what I would say is that in the 1950s, so gerrymandering was very much an issue, but it wasn't nearly as important. It wasn't to get the political result that one desired. People drawing districts didn't have to resort to gerrymandering as much if they could just stick X number of people in one district and an entirely different number of people in a different district. So while gerrymandering continued to be used for partisan gain, it wasn't as important for practitioners of redistricting as it became after the one person, one vote decisions. And I've always been mindful. One of my sort of favorite, favorite maybe not be the right word. One of the pieces of evidence that has most stuck with me was a newspaper editorial from the 1960s that referred to the twin evil of malapportionment and gerrymandering. Sort of the notion that both of these are responsible for undercutting majority rule in the United States and sort of enforcing a system of minority rule. So let me just tell you a little bit about how bad the problem actually was, because I think in our post-1960s world, malapportionment itself has gone away. We have to draw districts that have the same number of people in them, and so people, I think, often don't understand just how bad it had gotten. But it was pretty staggering, and it sort of this beginning around the turn of the 20th century, for instance, you begin to see increased malapportionment almost with every decade, every census. And it happens one of two ways. There are some states that had very specific state constitutional requirements to redistrict every 10 years, and sometimes it just didn't happen. So the legislature, for whatever reason, would just choose not to reapportion despite a constitutional mandate to do so. Other states had a system of redistricting that you might think of as the federal model, that more closely followed Congress, where you had a lower branch of the state legislature that was based on population and an upper branch that was based on other factors, geography, some sort of combination of the two. And so as populations changed throughout the United States quite dramatically, from 1900 and 1940, 1950, 1960, you really see huge shifts in where people live. And the redistricting, the reapportionment did not keep up with those shifts. And so you have every 10 years increase, the issue of malapportionment gets worse and worse. And in its sort of crudest terms, this is often painted as a rural versus an urban issue. And there's certainly elements of that, and we shouldn't pretend that doesn't exist. The population shifts in general were away from rural areas towards urban areas. Urban areas were also where you had the large, influx of populations from the late 19th and early 20th century immigration, populations that tended to be, disproportionately Southern and Eastern European, as opposed to Northern and Western European. And so there's a lot of change taking place in the United States, and that's reflected in who's coming to the country, who's living here, how those people are counted and represented. But I think it's important to be really careful about just sort of thinking about malapportionment in kind of crude rural urban terms. And California, where I now live and have lived for a while, provides actually maybe the best example, because the California Constitution of 1850 is very explicit that both branches of the state legislature have to be based on population. And that worked out pretty well for everybody up through the 19th century. But then by the turn of the 20th century, as Los Angeles and Southern California began to vastly outpace San Francisco and Northern California, you had, so it wasn't just rural interests who were sort of concerned about growing urban power, but it was also Northern California interests that didn't like what was going on with growing Southern California. To complicate matters even more, you also had urban interests in Southern California, business interests that actually did not want to see too much representation amongst the populace, which was largely, working class, pro-labor groups. And so you actually had this very interesting dynamic. In 1926, California passed a referendum in which they changed their system of representation so that it said that the state assembly would be represented based on population, as it had been since 1850, but the state senate would now be apportioned such that no county could have more than one state senator, and no state senator could represent more than 3 counties. So, and that was in place from 1926 into the 1960s. And so what that meant was that by 1960, with the massive growth of population in California, that by 1960, Los Angeles County had 6 million people, which at the time constituted 40% of the population, and had 1 state senator. And if anybody's ever gone skiing in California, I've been up to Mammoth Mountain, which is on the eastern side of the Sierra, up in a very rural part of the state, not far from where one of the really bad wildfires was this summer. There's 3 counties that have a combined population of 14,000. They also had 1 state senator. So literally you had, the vote of somebody in Mono County, California would have been worth the weight of about 450 people in Los Angeles in the state Senate. And so again, that's an extreme example. That was sort of one of the most extreme that I can come up with. Political scientists had a couple of different ways for sort of measuring malapportionment. One would be to sort of look at the difference between the most populous and the least populous district. So as this person represents 20,000 people, this person represents 60,000 people. It's a 3-to-1 ratio. The other way they did it was to often look at what was the theoretical minimum number of people who could represent a majority of the state legislature. And that in of itself is sort of a complicated one, which we could talk about more later, but I won't get into the details of it. In California, in the state Senate, as a result of this measure, theoretically less than 12% of the people could elect a majority of the state Senate. So again, huge implications there. And what's interesting is that you had business interests in Southern California who fully supported this, because again, they saw it in their interest that a more rural, more conservative, low tax legislature was in their interest. And so they considered, so again, these easy divisions between rural and urban are part of the story, but they don't really work when we really dig and drill down, I think, in terms of, who's behind the different measures. So California had massive malapportionment, but so did most of the big urban industrial states of the Northeast, Midwest. Michigan had a notoriously effective system of malapportionment, where it was, even though they would elect Democrats governor time after time, it became almost impossible for the Democrats to elect a majority of the state Senate. Illinois was another one. New York. So these are states which today, swing in different directions politically, but they all have a history of pretty excessive malapportionment. Now, of course, if the state legislature is malapportioned, then that means that congressional districts are going to be malapportioned too, or at least there's a good chance for it. And so you do have, to the same extent that state legislatures were increasingly malapportioned by the mid 20th century, the same thing happens with state legislatures. One of the most clear-cut examples is in Illinois, where finally in 1946 the Supreme Court issued its ruling in Colgrove versus Green, which was a congressional malapportionment case, where the most populous congressional district in Illinois at the time, which was northern, sort of the area around Chicago and Cook County, I think had 900,000 people in it. And then there was a district in downstate Illinois with 100,000 people in it. So again, you have, even within the state of Illinois, one person's vote counts 9 times what somebody else's does in congressional race. So all of this really becomes, the situation gets worse and worse. You have, as populations after World War II in urban areas begin to really swell, urban leaders, municipal leaders, boards of supervisors, city councils, et cetera, grow increasingly frustrated at the lack of funding for, hospitals, roads, schools, et cetera, all the things that municipal officials need, in part because the state legislatures are so overwhelmingly controlled by many rural interests or low tax interests, et cetera, et cetera. And so you begin to have the pushback begins really in the late 1940s. The Supreme Court, though, in Colgrove versus Green, this is Felix Frankfurter's famous admonition that the courts must not enter the political thicket, so that the courts had no business, the federal courts had no business being involved in malapportionment, a position which essentially is what the current Supreme Court has taken with regard to gerrymandering right now. And that was really the governing philosophy in the federal courts until the 1960s. So you had, even in Tennessee, which was where the case of Baker v. Carr comes from, where the Supreme Court finally decides to enter the political thicket, you have a district court judge acknowledging, he used the term evil as a legal term, that he recognized that malapportionment had constituted an evil, and yet he was powerless to do anything about it. That finally changes in the early 1960s, in the case of Baker v. Carr, when the Supreme Court agrees to hear arguments in the Tennessee case. Initially, one of the things that's quite fascinating for me as a historian, and probably it may have been the most interesting aspect of this just purely from a research standpoint, was to see, to get a hold of sort of Department of Justice, Solicitor General's memos and court papers to see how quickly the conversation around malapportionment changed just within, say, from 1962 to 1965. And so I think, and the key point being here is that in 1962, when the Supreme Court decided to hear arguments in Baker v. Carr, and the case there was not what would the standard of reapportionment be. The issue there was just whether or not federal courts could in fact hear malapportionment cases, whether or not the court, essentially overturning Colgrove versus Green. And in the case of Tennessee, it's interesting. Tennessee actually, the malapportionment was severe, but Tennessee was one of the handful of cases at the time which reapportioned based on the number of voters, not on the actual population. And that was never an issue. No one at the time in that case ever questioned the validity of that. That was not an issue in the Baker v. Carr case. But what was at issue was that, however Tennessee counted it, that people in one part of the state got essentially 10 votes versus someone in another part of the state who got 1. And that was fundamentally, the court felt that this was an issue that the federal courts should in fact, it may in fact violate the Equal Protection Clause of the 14th Amendment, and therefore the federal courts should in fact step in and or at least hear the case. And so that really then opened the floodgates. And then in a matter of the next 2 years, I don't have the statistic in front of me right now. At one point I looked, I think it was like 75 cases from around the country dealing with both state and congressional malapportionment were filed and began to churn their way through the court system. And it took 2 years. Finally, about 15 of those cases made their way to the Supreme Court. And the Supreme Court ultimately heard oral arguments, I think, in 6 of them. And this is another one that was just sort of as a historical footnote. You all may remember a couple of years ago around the Affordable Care Act, I think the court spent 3 days hearing arguments on the court, usually they just hear 1 hour of arguments on a case, 30 minutes each side. Affordable Care Act, I think it was 3 hours over 3 days. With the reapportionment cases, it was something like 20 hours over 8 days spread out over the entire term, because different cases kept reaching the court that posed the question in different ways. So it's a fascinating, and it's all, the recordings are all there. So there's a great record. But the issue really, it was not clear when the court first began hearing these cases, how far the court would go in terms of what the standard should be. There was one line of argument that certainly the states, it would be reasonable for the states to mimic the federal government and to have one branch of the legislature based on population and another based on other factors. And in fact, one of those, again, great sort of research moments in Earl Warren's papers, there are 2 drafts of his final decision, one which only goes so far as to hold that. And then there's the decision, the other draft that he eventually submitted and the court signed on to, which said that both branches of state legislature had to be based on population. And I think, how do they get from point A to point B? I think it was really struggling with a number of the different cases that had reached the court. And the final one that was most instructive came from Colorado, where Colorado had, it was called the Colorado Plan. And it did base the lower branch on population, and the other branch based on, the upper branch based on a variety of factors, including geography, but it clearly privileged certain mining interests and ranching interests. And so I think there was a lot of back and forth about whether or not this plan, while it maybe was more equitable than a number of other states, did it still not to go too far? And so ultimately the court, I think, felt that there was no standard that they could issue other than, you know, a fairly strict one person, one vote standard in both branches that would make sense. Otherwise, there was always going to be back and forth, and well, where do you draw the line? Is it at 42% of the people elect the majority of the legislature? Is it 44%, or is it 36%, or 48%? You know, how many people is the right number? And so ultimately, they decided this issue in terms of one person, one vote in both branches of the legislature. It's important to note that the court did very deliberately choose the language of one person, one vote, as opposed to one voter, one vote. In a related case a year before that actually had to do with the primary system in Georgia, William O. Douglas had issued an opinion in which he initially had written one voter, one vote, crossed it out, wrote one person, one vote, and then that language is then adopted into Reynolds v. Sims and Lucas v. Colorado, which were the 1964 cases which established one person, one vote. So the court did make a very clear determination at that point that person rather than voter was the operative term that they would use. Let me just say very briefly, and sort of because Wendy had mentioned this, that the Supreme Court decisions of 1964 did open up a wave of criticism, but also a lot of support. I mean, there was an enormous amount of support amongst, especially as you might expect, urban-based newspapers and media groups, legislators, citizens, et cetera. And then a wave of opposition to the court's decisions, which did actually lead to a campaign to call a constitutional convention. Back up a second. First, the U.S. Senate on 3 occasions tried to push through a constitutional amendment to overturn the decisions, and they got more than 50 votes each time, but never could get 2/3. And then, led by Everett Dirksen, who was the senator from Illinois and the Republican minority leader in the Senate at the time, launched a campaign to try to call an Article 5 Constitutional Convention, which of course has never happened in American history, but it is there in the Constitution. It says that there's two ways to amend the Constitution. One is to pass a constitutional amendment. The other is to call a convention and have it do its work, and then submit the work back to the states. And over the course of the next several years, they would have needed 34 states to call a convention. You need 3/4. And they got as many as 32 states at one point in time. Now it's always hard to know whether it was really that close to being called, because some of the states had then rescinded their petitions and then had changed the wording. But there were 32 states at one point in time that called for a constitutional convention to overturn the decisions. But as the one person, one vote standard began to be implemented, it became more and more difficult for people to argue with. I think more and more people accepted it, recognized that it made sense, that it was, in terms of a functioning democracy, it would make sense that these guardrails were in place. And then Everett Dirksen, who had led the campaign, actually died sort of suddenly and unexpectedly, and that sort of took the final wind out of the effort, if you will. I'm going to pause there because I feel like I've talked enough. I'm happy to take any questions or to go into deeper detail in any aspect of this, if anyone has any questions, but I'll just stop there for now.
Thank you. I really appreciate what you've shared with us, and there are several things that I could drill down on. I do want to be sure that other people who would like to say something have the opportunity. So let us know if you'd like to ask. But Doug, one thing that crosses my mind is that I'm trying to make comparisons between what happened in the 1960s and where we are now. And one was that the Affordable Care Act was enacted and lots of furor about that, but over time, it just became settled law. Is that a good comparison to how the implementation of one person, one vote caused some furor and then it just settled down? Is that, and maybe there's other examples like that.
Yeah, that's a really good question. I certainly haven't, I haven't thought of it in those terms. And so so I'm speaking totally off the cuff right now. I suppose, I mean, I guess we could have a separate argument whether to the extent to which the Affordable Care Act is truly settled law, given that there continue to be efforts to, to overturn it or undermine aspects of it. I mean, I do think that in a democracy, there's a certain logic inherent in majority rules, and I think that the system was so broken that it was so screaming out for reform that even if imperfect, that the notion of one person, one vote made sense to most people. I mean, I had a chance to ask a gentleman who was Earl Warren's head law clerk that particular year and who worked on these cases. I asked him this issue about, well, why did you all think about addressing gerrymandering in these decisions? Why did you not? And he said yes, there was definitely a discussion about that, but it was felt that wasn't nearly as important an issue, and that would be better left for another day. And of course, here we are 55 years later, and it's still there. But I think so. It's important, I think, just to recognize just how severe malapportionment was beyond any almost anything we can really imagine today, and just how distorted the system was at the time. And as I said, almost every state in the country. I'm trying to remember. I know that there were 5 states I remember identifying that Massachusetts was one. I think Wisconsin, West Virginia, Oregon maybe, and one other who had by 1960 had fairly equitable apportionment of both branches of the legislature, but almost every other state in the country had at least one, if not both, were really, really out of whack.
I guess another thought that I have is back then really out of whack was 9-1, or you gave us some other numbers, but that's the one that I got. Now courts are still looking at what is reasonable for legislative districts, and is something under 10% deviation. That would be 1.1 to 1. Is that always okay, or sometimes could still be a sign? So it's almost like we went from anything goes, 9-1, 420 to 1, whatever, down to 1.0001.
Right.
So maybe the same things. Joe, are you out there, and would you like to come on and ask a question or make a comment? I'm thinking of Joe Lamson.
Yes, I would.
Yes.
Interesting, Doug. It was precisely the same pattern in Montana that you were outlining in Colorado that went there, and but the positive spin-off from many of us in Montana was that it was so bad that the people rose up and redid their constitution, and it benefited not only in redistricting, but redistricting was what the major drive behind that. And they concluded that the legislature's inherent conflicts of interest required that a citizen commission, and they established the 5-person citizen commission, which was the 3rd in the country, and has been going on ever since. Our biggest threat is that the legislature decided to follow that the first 3 times we've done it, and now the next 3 times we're doing it here, at least half of the legislature has decided that they want to go back to the old way, and so it's a constant tension. And
Yes.
The first time that we're getting to get our congressional district back, it brings all those forces forward. So it's interesting.
Yeah.
And I should have commented that this is Commissioner Lamson from Montana, so he knows of what he speaks. Doug, do you want to make any comments on that?
No, it is fascinating once you start drilling down into the experience at each state, and to see how this all does play out.
And Will, let's get Will off of mute. And
sure. Hi, Douglas. Thank you so much for that talk. It was really interesting. So I guess I'm wondering if you can comment on how much of the public imagination these issues have actually occupied. So, I think today many people believe that the general public, if they know about redistricting at all, underestimates the effect that redistricting may have on representation relative to other things that are a little bit more easily understandable, like voting rules and voter access and things like that. So, with these critical rulings in the 60s coming in the civil rights era with so many other representational issues at hand, how much do you think that your average member of the public was actually thinking about redistricting relative to all the other issues? How much radio coverage, how much TV coverage did these, mainstream radio and TV coverage did these issues actually get, and the rulings?
Yeah, that's actually a great question, and something I did spend a lot of time thinking about, because I think in many ways the one person one vote rulings are every bit as important for our democracy as the Civil Rights Act or the Voting Rights Act. But I think the answer to your question is very little to none in terms, certainly, especially if you think about the nightly news then was 30 minutes and there was 3 channels, and they wouldn't have, to Wendy's comment earlier about, this is not a classic page turner, although there's some great drama in the courtroom, but it's not the kind of stuff that's going to make the nightly news. There's no question about it. This is sort of, nerdy, and I use that term affectionately, lawyerly, these are lawyers cases, lawyers bringing this, and, in Alabama, the lawyers, going up and signing up a few of their friends at the Rotary Club to serve as plaintiffs and things like that. So I think you do see a fair amount of editorializing in the major newspapers about this issue as it becomes more and more of an issue. And so you do, I think there is a growing sense throughout the 50s and the early 60s that there's a real problem here. Groups like the League of Women Voters was all over this issue and made this one of their primary, there's some great materials in the Library of Congress, like the state branches of the League of Women Voters, where going back to the 40s in different states, they're tapping into this and figuring out, so they are raising general awareness. But to your question, for the public at large, I would say not very many. This was not an issue that people were coming home from work and talking about around the dinner table. But I think that for, there were people who did recognize the importance of this. Some of the, I think it was Walter Reuther, some of the labor leaders who, there was one point at which Walter Reuther was offered a deal on, Taft-Hartley that he had been seeking for 40 years, but sort of in exchange for not pushing reapportionment. And he basically said, no, reapportionment's actually even more important to our cause at the end of the day. So I do think there's certain areas of people who are engaged politically, who are involved, who understand the real importance of this and of a more equitable apportionment. But for the average American viewer coming home from work, who might be watching the news and seeing civil rights demonstrations or later anti-war demonstrations, I think it's minuscule compared to that.
I think you said in the book that the Chief Justice also, when asked what was the most important case he ever decided, it was one of these. Can you bring that back to life?
Yeah, when Earl Warren announced his retirement in 1968, and he actually ended up serving for another year, but he was asked, what is the most important decision that your court ever handed down during your tenure? He said the reapportionment decisions were first, and then Brown versus Board and the segregation decisions second, because I think he maintained that into his retirement. Whenever he asked that question, he said he felt like these were the cases that were most fundamentally important to the structure of American democracy, and for that reason, he always listed them as first.
That makes me feel good, and all the people who are on this call too, that we are working on the fundamental issues of democracy. So right. That feels good. Jeff, are you there? And do you want to put a historical perspective in here as well? Jeff Weiss, I'm talking about.
Okay, I will. Hi, good afternoon. I'll repeat what I put in the chat box. A unique story. A late friend of mine, Georgetown University professor Roy Shotland, once told me the story that when he was Justice Brennan's clerk in the early 60s, that he worked with Brennan to determine the deviations of the legislatures or congressional districts in each of the justices' home states. And that one Sunday afternoon, he was driving Brennan around DC and left him off or waited for him outside Justice Tom Clark's home. And when when Brennan came back to the car, he told Roy, like, we've got the majority now for finally for Baker versus Carr. And it was based, from what he told me, in part on bringing the message home to each of the justices. I'll take it. Roy is no longer with us. I'll take it that that is a true story. And it was an interesting one, that all politics is local.
Well, that is fascinating. I wish that you and I had met 10 years ago, and that sounds like it would be a great story to include. I had not heard that story, but I do know Mr. Shotland's name, because one of the things that Justice Brennan did was he had his clerks at the end of every year write essentially a really detailed history of the most important cases from that term. And so one of the best accounts we have of Baker v. Carr and of what happened behind the scenes is, and I think Roy Shotland, that might have been one of the clerk who authored that particular memo. And so there's a lot of detail. I mean, the Baker v. Carr case, initially it looked like it was either going to be initially it was the first time it was argued, it was decided it was 4-4 and they put it over for re-argument. And then it looked like it might go 4-5 or 5-4 either way. And Tom Clark, it was interesting, in Felix Frankfurter, who was the most vociferous opponent of weighing in on Baker v. Carr, suggested that Tom Clark should write a memo. Tom Clark initially was going to dissent along with Frankfurter, and he suggested that Tom Clark write a memo outlining the alternative avenues of relief that the plaintiffs might seek. And Tom Clark apparently sat down to do that and realized that there weren't any. And so he then switched his vote in part. So, and that may have been in part because of Brennan's personal lobbying of him as well. So no doubt that made a big
I
difference.
taught all the cases you just mentioned in my law school class in the last few weeks. I mentioned after Baker v. Carr that it said that after the case finally was decided, Justice Whitaker resigned from the court, possibly over the mental stress that Baker v. Carr presented, and that Justice Frankfurter had a stroke shortly afterwards.
That's correct. Well, and Whitaker, the final decision in Baker v. Carr was 6-2 because Whitaker had was clearly distressed, and there was a lot of evidence that Baker v. Carr was sort of the final. He was getting so much pressure from Frankfurter, and he was really torn about the decision. And Frankfurter was really leaning on him heavily, and he had a hard. So he did end up not taking part in the final decision because he had already gone into the hospital at that point in time. So several weeks before the decision was handed down. Yeah, and then Frankfurter had a stroke about a week later.
Yeah, when you look at the early cases, this even takes us into the 1980s, how justices used the same set of facts, but had totally polar views of how to decide cases as late as Mobile versus Bolden in 1982, where you had Stewart on one side and White on the other. Also just mentioned my last comment. I think I used your book a few years ago. I did an article on Robert F. Kennedy as Attorney General and redistricting, and mentioned the Gray versus Sanders case, which I think you talked about.
Gray v. Sanders is the one that I mentioned when William O. Douglas wrote the opinion, and that was sort of when the court struck down Georgia's county unit system, which was not technically a malapportionment case, but as you know, was essentially it's essentially the same issue, and that's when he used the term "one person, one vote."
Right.
Well, that's fine. I would love for your because I've always been fascinated by the Kennedy Justice Department. I think it's a that in itself is a remarkable story in terms of that.
Well, so my thought is that maybe we keep you, Doug, and we go do a couple of other things, and then anybody who would like to stay and continue this conversation about the history, stay on board. And then if any of us need to, go off and do other things, we understand. Are you good with that, Doug?
I'm fine. Yeah.